going to say hello. We're getting started. Thank you very much to the virtual audience for joining us. Today we are, well, first, let's make sure everybody's in the session that they want to be in. We're going to be talking about decriminalization advocacy post Martin v. Boise. Martin v. Boise is a case that presumably you're familiar with if you're here in this room. It was brought by Idaho Legal Aid, Latham and Watkins, and the Law Center, challenging two different ordinances in Boise, Idaho, that criminalized sleeping and camping in public places when there was not even temporary shelter available to people. So we'll talk about that case, which resulted in a decision from the Ninth Circuit, which has had an impact. We can argue about the pros and cons of that impact, but it has had an impact. We'll discuss what Martin holds, what it doesn't, and then we'll also talk about some other things. This is a session, a little bit of an experiment. We're going to try to be very interactive. So I'll be moving around the room because we have several different speakers who will be answering questions with this microphone. I apologize to the folks virtually. You're not going to be able to see everyone. But this is something of a, you can think of it as a game show format. I don't mean to be light or flippant. We're talking about life and death issues. So when I say game show, I'm referring to the format of this session, not the topics that we're discussing here. But what you'll see is that we basically have three different interactive segments of today's meeting. The first thing I'm going to do is ask questions that are designed to highlight what Martin holds, what we know is settled under Martin and precedent, interpreting the Eighth Amendment or interpreting the scope of Martin, and what it does not, so that we can be really clear about how to wield that tool. And as we move along, we'll talk about strategy, and then we're going to end up talking about some of the common lies and getting really comfortable calling those out. So let's go ahead and get started. Can everybody virtual hear me all right? Thumbs up. I'm seeing thumbs up. That's what I like to see. Very good. All right, so let's start with the first. Martin says. All right, this is Martin says. Now, okay, so I was born in '77. These are going to be a lot of '90s pop culture references. I like to hear it. All right, so first, and what I'd like to do is I'm going to ask this question. These are kind of framed in yes, no, true, false kind of format, and I want to hear people in the audience shout out an answer. And please, virtual audience, put something in the chat as your answer. And then we will go to our official answer. All right, let's start. First, does Martin guarantee a right to camp in public space? All right, I'm hearing no's. I'm hearing no's from the in-person audience. Please put your yeses or no's in the chat. And we're going to go to the great Kirsten Anderson for the official response. Does Martin guarantee a right to camp in public space?
No, it does not. However, when there is no availability of alternative episodes to sleep, and because there is no community about sleeping, not arrest and the activity of sleeping and sheltering. Because if you just describe for us what's the significance of not having a right to be in public space? What does that mean as we think about decriminalization advocacy and how to really achieve that?
Yeah, that's a very complicated question. But I guess that's the most of it is that is the difference and the Eighth Circuit, or the Ninth Circuit, the Ninth Circuit, the Ninth Circuit, is called Joel versus the City of Orlando. Joel versus the City of Orlando upheld a camping ordinance because it said it punished conduct, not the status of being homeless. And in a case that I litigated in the district court in the 11th Circuit, the district court kind of reconciled the two and said they both are vested on the same legal principle, which is that under unconstitutional amendment. But the distinction between the status and the conduct is the available in the utilities, and whether or not someone is voluntarily outside involuntary. I think the most significant about that is it is not really guidance further towards the right to housing. And we've got one of these situations that we have to include the availability and viability of the shelter system to that matter. Thank you very much. All right, next question, shout it out. Does Martin stop the criminalization of homelessness? Is there no more criminalization of homelessness because of Martin? I'm hearing laughter, and I'm going to assume that is in. All right, I see a thumbs down. And you're right, no. No one case is going to stop the criminalization of homelessness. As we talked about yesterday, the government has a lot of tools in its tool belt for coming after people who it wants to come after. You can, in a case, stop, strike down, get a law to be repealed or rejoined. What you're not going to do is stop criminalization cases with a litigation strategy alone. Litigation is a tool that should be part of movement building, power building in the community, and it can be a tool that we use, but it will not stop criminalization. All right, so let's move right along. Does Martin apply only to citywide camping bans? Are we limited in our challenges under the 8th Amendment to ordinances that criminalize camping in all spaces at all times? It's a little trickier. I mean, the first two were kind of, lobs. And don't be embarrassed, because a lot of these things, like we're talking about, some things are settled, some things aren't, and open to interpretation. You can go ahead and shout it out or think to yourselves. Please put in the chat. And we are going to go to, are you able to spotlight great. So we are going to Ed Johnson, Director of Litigation at the Oregon Law Center, for our official answer to, does Martin apply only to citywide camping bans?
Good morning from sunny Portland, Oregon. I don't know if everyone can hear me, but that is a tricky one. I think the answer is Martin does not only apply to singular citywide camping bans. For example, in our case against the city of Grants Pass, Oregon, we successfully challenged a patchwork of ordinances that included 2 different camping bans, an anti-sleeping ordinance and a park exclusion ordinance that effectively made it unlawful to engage in a wide range of life-sustaining conduct at all times of the day or night in every inch of public land. And the 9th Circuit so far has agreed with us that the patchwork method works as well as a singular camping ban.
Thank you. And so were you able to hear Ed in the audience? Great. So, in the Grants Pass case, they were able to show that there was no lawful place where people could sleep, not under a single law, but under a patchwork of laws. So you can do an analysis to find the codes that make it impossible to lawfully survive in public space and have that be the basis for a challenge under the 8th Amendment. All right, so let's move right along. We're going to stay with our official answerer, Ed Johnson. Does Martin apply only to resting conduct? To resting conduct. And I'm talking about sleeping, sitting, lying down. Is that all that Martin or the 8th Amendment applies to? The only universal and unavoidable activity that the court's going to consider? These are tricky. Please don't be shy. And you can shout it out. There's a time later where I'll actually ask you to shout out, but you can think to yourselves. Anybody want to venture? And it's going to be it depends a lot. So we've got an it depends, and I think the it depends was decided favorably in the Johnson v. Grants Pass case. So I will kick it over to Ed. How would you answer the case? Does Martin apply only to resting conduct?
I think Johnson versus Grants Pass clarifies that it does not only apply to resting or lying down or sleeping. It also applies to other acts that are necessary to keep yourself alive and out of the elements, warm and dry under a blanket. I think the big unanswered question is whether that might include tents, the necessity of pitching a tent and living in it in order to stay out of the elements would seem to follow that logic, but the Ninth Circuit majority in both Martin and in Johnson specifically said that it probably does not apply to tents, which I think it may be more because of the politics of tents than the logic of that argument.
Thank you very much. Everyone heard Ed? All right, very good. How many lawyers are in the room? Okay, which lawyer wants to describe very briefly what standing is? Standing to bring a case. Don't be shy. I'll call on somebody. A person who can show that they have a concrete and particularized injury. There's Article 3 standing. And in order to bring certain claims, you have to show that you have standing. So one of the questions is, do people who have never been arrested for camping have standing to raise a cruel and unusual punishment claim under the 8th Amendment? Well, that and it depends. And it depends is a winner. That's never going to be, it's never going to be the wrong answer. You're hearing, and I will make sure that you can hear even better from our awesome. How's it not hear us from you?
It depends on the circuit, but arrest and sometimes establish things. There's people who like really find out wrong. We have or goals like this organization somewhere. Some certain about conviction.
Excellent. That's right. It depends. And now in the Ninth Circuit, a credible threat of prosecution is enough to establish standing, a credible threat of prosecution. So if a person has been punished under that law before, they're still engaged in the conduct that is prohibited, they are likely to be able to establish a credible threat of prosecution. In the Fifth Circuit, you need an actual conviction. So it's a difference in the law across the country. And it's important as we craft our legal strategies that we think about it. Most circuits in an analysis done by the Law Center really have not answered the question. So it's an open question in a lot of places where you all may be practicing. Okay, let's keep the party going. What does shelter mean under Martin? We know that there needs to be some sort of shelter alternative. The court talks about that, but what do they mean? What is shelter? Anybody want to shout out an answer? What is shelter? I mean, we know that typically what shelter is and how it's offered in terms of services in this country is a setting that is congregate in nature. You might have a cot or a mat next to a stranger in a large room with several other strangers. It'd be available to you only overnight, and it is indoors in a building, often offered by a faith-based organization. That's sort of a general description of the nature of shelter services across the country. Is that what shelter is? What is shelter?
I'm hearing, I apologize for those in virtual one, you can walk over. That's like the filter, that's the filter, they're but usually provide experience of them. Excellent answer, Lydia. We're going to go to this, Sarah Stoneheimer, who is with the Services in Northern California, for our official answer based on her lawsuit regarding disability.
So Martin just doesn't really discuss what health is at all. It's the terms of what uses, sleeping indoors, beds, and adequate temporary shelter must be spent at the Martin discussion. In our case, the city tried to argue in court that a plot of land with stairs where people could go to the shelter that is next to next to the public. And they did provide for facilities, hand washing stations, and water systems and dumpsters. And they went in court and said this is shelter, this is space that people can be. And the court said that's not past the street case test, really just look at the dictionary and looked at what is shelter and found that it has to offer elements of protection. And looked to Martin and said at the very minimum it has to be indoors. And also suggested that this airport site is not sheltered because there's no roofs, there's no walls, no water, and no electricity, and no real protection. So at minimum, indoors with some absolute protection, running water, I was at the 56 that probably.
And we're going to stay with Sarah for our next question. So one area where very much the communities are still trying to figure out what it means for shelter to be practically available to a person. And so the next question would be, you can be something shy if you want to shout out with anybody's there for the official answer. But does this conception of practically available shelter include people who can't access shelter due to a disability? So is a shelter not practically available to a person based on their disabilities under Martin? Is this on my head shaking?
So Martin does not discuss disability at all. Martin does discuss the views that are in the shelters in Boise and found that jurisdiction must look beyond Washington and Northwest, right? They look at whether or not people will actually bring their way from the shelter. The two issues in Martin the court discussed for time limits. So some you got something for 30 days, you're outside of that time, that's something you available to you, and then it's just but I would argue that under Martin there is some depending on the facts of the shelter, there could be other reasons that is not functioning. I'm saying other policies that function in Martin. And actually Ed's case in the Vance Pass case, the lower court and then both do talk about how in the case some people could be able to shelter due to disabilities. And then the ultimate finding in the Minnesota case is that the shelter is a secular shelter. So I think it's
all right, so stay with this notion of shelter. We know that it is important to the whole in Martin's situation. Does the court find that governments are required to provide shelter or housing? Okay, I heard a no. Yeah, this one is a little bit less. It depends.
Yes, and personally, that's thoroughly protected. And this is an interesting issue because Martin specifically says it's very thorough in documentation. And there is no requirement on the housing shelter. However, like the way we approach this in our case, the comparable and Florida is that they said, oh, plaintiffs are arguing that they want us to run out one spread shelter, the policy is about them being upset with our housing services. And we said, no, you're welcome to have the system you have where you're not housing people and not sheltering 150 people. I'm sure that it's really not a big deal. But you cannot arrest people in that.
And just a quick follow-up question, does Martin impose any affirmative duty to provide services of any kind?
I can elaborate, I guess, but yeah, no, there's no affirmative duty. However, I think when we're kind of structuring the reality for the courts, I think it's really important to show what would be done, because when you compare that to what is being done, it makes it clear that it is not a choice for the people here.
You touched on this a little bit, but we're going to talk about Martin's authority. So does Martin apply outside of the United States? We all know it's binding here in the United States. Does it apply at all outside of the United States and the rest of the United States? And Kirsten, who would be able to answer that question. But first, this is funny that we just push out on top of that.
Yeah, persuasive is also different. So folks who work and use the word work outside of the main circuit know that perversity was not so good in this reason. And so we have to have a job and we had a particular problem in the 11th circuit. Kirsten, the city petition for cert in the market. They cited the Joel versus City of Orlando as evidence in the circuit split. And they said this is why this case. And so we were very intentional with Kampala working against negative precedent, and we had to convince our court that the legal principle was the same, that you cannot punish people for the status of being homeless. And when you criminalize sleeping, which is essential life-saving conduct in this capacity, but sometimes in some place there that all humans then that legal principle is the same. The difference in the 11th circuit Joel is that it was unrefuted that shelter was totally available, because there was a affidavit filed by a shelter who said, "Oh, we always have space. Anyone can come at any time." And so we looked at that and said, "Okay, well, this is going to be really important to develop as a factual record to show." Not only that people were involuntarily unsheltered, but also that they were involuntarily homeless, because we wanted to make sure there weren't assumptions. And I also wanted to give a shout out to Cotton versus today. We made them our first Boise, and really pioneered this about rights. And it's really, if folks haven't read that decision, it is really worth it. And I have actually sections of those into the application questions for witnesses because I want folks to know this.
And the Pungarcher came out of the Miami-Dade Public Defender's Office, shout out Miami-Dade Public Defender's Office.
And you are 25.
And I don't know if I mentioned this, I happen to be a former Miami-Dade Public Defender. All right, so We know that Martin looked at and evaluated 2 criminal ordinances in Boise. It applies, the 8th Amendment applies clearly to cruel and unusual punishments by criminal ordinances. So the question now is, does Martin apply to civil penalties? One of the reactions that we saw to the Martin decision was amendments of laws or newly enacted laws that instead of imposing criminal punishments, they imposed civil punishments. You just get a ticket for your unavoidable life-sustaining activity in public space. Does Martin apply in that setting? That's right. We're going to go with it depends as the in-room answer, and we're going to kick it over to Ed Johnson for the official answer.
So the Ninth Circuit has recently held that clarified that Martin and the 8th Amendment do apply to civil penalties when they are closely intertwined with criminal penalties. So for example, in Grants Pass, our clients were charged with violations, civil violations. They were given $300 tickets, but if they went back to the place that they'd been told to leave, usually a park, they were then subject to criminal trespass too. So, and that built on a case out of the 4th Circuit, Manning versus Caldwell. There's also another line of cases that suggests that it doesn't have to be linked at all to criminal punishment in order for the 8th Amendment to apply. But that line of cases has not been applied to the homelessness setting yet.
Thank you very much. Now, one technical difficulty we're having is that you can't see that we're transitioning to our next session. Would you mind asking? Thank you very much. So we can get these slides to show. I'll just turn my computer so everyone can see. We're now transitioning from Martin Says to strategery. Strategery. We'll be talking about strategies for bringing these cases. And first, and this will be a little bit less interactive, but I do think that these are really core considerations as you're crafting your decriminalization strategy. So we're first going to go to Ed and talk about strategies for avoiding mootness and for securing broad relief. And I know that this is something that you considered and have been successful in doing in Johnson v. Grants Pass. So I will pass you the mic.
Thanks, Tristia. So we brought a class action in Grants Pass, and it was fought pretty aggressively by the city. And so far, so good. The district court certified our class, and the Ninth Circuit panel declined to decertify the class. I actually think this is a pretty big deal because the ability to challenge these ordinances by class action really shifts who has the burden of showing that someone is involuntarily homeless, which seems like something that shouldn't generally be in question. But cities, not surprisingly, including in our case, as they seek rehearing en banc in the Ninth Circuit, they want to be able to ticket anyone. So the way this plays out is in the middle of the night when a police officer approaches someone who's living outside, who has the burden of proving that that person is in fact, unable to find housing and has engaged in an exhaustive, search for shelter. If the cities have their way, they will be able to ticket everyone, find them, bring them into court, force them to show up at court and raise an affirmative defense to show, in fact, that they are low income and that they cannot find shelter, which would effectively eliminate anybody's ability to assert their rights. So class treatment, I think, is really important, but if you work for an LSC funded organization, don't fret. There's other ways to do this, including what happened in Martin, which was not a class action. You can bring a prospective action on behalf of a group of individuals. That does run the risk that those folks will have standing issues, which was a big ordeal in Martin. But you can also represent an organization that has standing to bring these claims on behalf of a group of individuals.
Thank you very much, Ed. And I'll just note that the Law Center has a memo on organizational and associational standing. So if that is helpful as a resource, please know that we do have that. And just one follow-up question around mootness. So one of the things that that we know is characteristic of litigation is that it takes a long time. And it's a significant time investment. And many people who are plaintiffs may not still be unhoused as the case continues on. And there's, a question of mootness. So can organizational plaintiffs help to address this concern about claims being mooted out because a person is no longer unhoused and subject to the challenged ordinances?
Yes, I mean, either a class or an organizational plaintiff just avoids the sort of transition that people's lives has over many years. I mean, Martin lasted many years. The Johnson case appears to be on that path. We're in our 5th year of litigation. I mean, people's lives change. They leave town, they get housing. And so anytime you represent an individual or a group of individuals, you're going to have a problem. Now, of course, nonprofit organizations go away too, but they have a better chance of sticking around throughout the life of a litigation. I do think a class, if you can bring a class action, may be the best method, at least for now, until the courts tell us we can't do it that way. I think that, representing all of the involuntarily homeless people in a jurisdiction is a sure way to avoid mootness, because unfortunately, that's always going to be a group of people that have standing.
Thank you very much, Ed. One thing I just want to note just about today's session is that a lot of the next speakers are virtual, and I don't see them being projected on. Would you be able to project their faces? We're taking a brief pause for technical assistance. Is there a way to project faces? That's more important than my strategic slide.
What do you mean? What faces?
The virtual faces, yeah, because a lot of people answering the questions are in the virtual.
Okay, well, if you're going to join from someone sitting there.
Could
Join from here?
yeah, that'd be great. Thank you. All right, stretch, get some coffee. We're going to take just a brief moment. And then we're going to be going to Jeff for more procedural strategy. Okay, I'm gonna stop sharing.
Okay, so.
Great, thank you. And folks online, just FYI, this session does come with CLE credit. I am not going to be able to pull it up on my phone until the end of the session. So be on the lookout for those 2 words at the end of the session. Thank you very much. Should just be another minute. I think we're going to be able to get you projected up for the full audience. Thank you. Thank you very much. And can I get the should I just get out of here?
Testing. Hold on, let's see something. 1 second. Testing. Yeah, go ahead and just go there. No, the arrow.
And turn the volume all the way down. Is that?
Testing. Yeah.
Will that give feedback to the rest of the virtual participants? Do you all have feedback? Feedback, no feedback? All right, very good, great. And can I get the slides projected as well?
That's a good question. I think 11 is.
I just go to the PowerPoint, just like
Oh,
normal.
this
Okay,
one.
perfect. Yeah, thank you so
All right,
much.
no problem.
And there was a comment in the chat, when you're away from your computer, they weren't able, even with the microphone, to hear you or the other speakers in the room.
Oh.
It was very muffled and robotic. And so I don't know if you can.
Okay, can you hear me? Out in the virtual land, you can hear me. All right, great. And I understand that you all were not able to hear particularly well when I was walking around with the mic. So we're going to switch it up and have people who are answering the questions once they're in person to just come up and be right here on the mic. All right, we're going to get started again. Thank you. Thank you. Thank you all very much for your patience as we resume with our discussion of strategy. And we are going to turn it over to Jeff Preptit, who is an attorney at the ACLU of Tennessee. And some of the questions that I want to ask you, Jeff, relate to timing and issues of abstention. So if you can first kind of tell the audience what we mean by abstention and what people should anticipate as it relates to timing for filing lawsuits and avoiding, if they can, abstention issues. Thank you very much.
Yeah, of course. Good morning, everybody. So, oh, you cannot hear me.
Can you tell this is our first hybrid? I'm sorry. Okay.
Let's see.
Thank you. I appreciate the grace that we got from the audience. It is a learning process, and I'm not sure. Oh, Jeff, I'm so sorry. I think.
Oh, no, it's fine.
Here, I think the folks virtually can hear well, but the in-audience folks couldn't hear. So I'm going back to my laptop. I've got like laptops in front of me here in person. I'm going to turn this up to full volume. And now, Jeff, abstention, heck, younger. What do we need to know?
Yes. So can y'all hear me now?
Yes.
Okay, perfect. Good morning. So essentially, there are a number of abstention doctrines within federal court. Mainly, just these doctrines mostly just dictate what cases they will and will not hear based off of what procedures are in place within the case and what has previously taken place. One of the main abstention doctrines that we've got to worry about here is the Heck abstention doctrine, which Martin v. Boise actually talked about pretty extensively and has a relatively good summary on the way that it operates. Mostly, essentially what it says is if a person cannot bring a federal 1983 suit challenging the constitutionality of a statute under which they have either been convicted or are currently in the process of having an open criminal case where they're actively being prosecuted unless they have what's called essentially a favorable resolution or a favorable termination in the case. What the favorable termination generally states that the conviction or case has either been dismissed, it has been overturned on appeal, you've either been had it expunged by an executive order from the governor, or declared invalid by a federal courts in a habeas appeal or some sort of post-conviction matter that you've then brought to try and negate the case. So essentially what it says is if you've either been arrested and you have a pending case or you have a conviction for it, you've got to exhaust all of your state remedies before you can try and get into federal court to challenge the statute under which you've been convicted.
Thank you. Oh, I know. Muted. Is this echoing and feedback?
Okay.
All right, so what I'm going to do is I'm going to shout out, just as we're configuring, the first CLE word, strategy, not strategery, strategy. This is for CLE credit. All right, and it doesn't seem like we have too much echo or feedback, but my audio is coming through in the next room.
Are you on the same?
You went to the wrong.
Are we on the same?
Sure.
That's good.
You know, if it's easier, were you all able to hear well enough when I just did the thing? All right, so I don't think we even need to. Thank you. Thank you very much. I appreciate that. So we're going to go ahead and stay muted there. And can you hear me, virtual land?
Yes.
All right, very good. No feedback?
No feedback.
All right. And all right, so we're gonna move forward. Now, thank you very much to Ed and Jeff, who helped us think about some of the pure legal issues, procedural issues that go into a decriminalization legal strategy. But they are not the only considerations, and arguably they're not even the most important considerations. What we know is that lawsuits, and we talked about this earlier, lawsuits alone don't bring social change. Lawsuits alone are not going to stop criminalization of homelessness. That happens with organizing. And there are strategies that involve organizing that are relevant to development of our legal strategies. And we've got a couple of great people here today who can talk a little bit about what they've been doing to that effect. So first, I'm going to go to Maig Tinnin, who is in Medford, Oregon. You're in Medford, is that right? Yep, who's in Medford, Oregon. And Maig, can you tell us a little bit about what organizers can do to collect valuable information to support decriminalization, litigation, and other advocacy strategies?
Yeah, I'd be happy to. I guess I just want to say too, because I know there's a lot of attorneys in the room, that I think one of the challenges can be really for organizers taking in so much information for being on the ground, and there's so many different issues and concerns. It can be really tough to identify like what is the important information that we need to focus on, what do we need to potentially document if we're working on a legal strategy as well, and then what isn't going to work through legal means, and then we want to kind of focus on that more from an organizing strategy. So just want to say, be patient with organizers, because we can get really overwhelmed with the amount of information we're taking in. So really, that's really helpful to kind of have time to like break down and work on strategy together. Some of the strategies that we've used that have been really helpful is building strong relationships with mutual aid groups, or if you don't have a mutual aid network in your community, services that are more values aligned, and figuring out places that are really great to meet up and build those like ongoing connections with people. I'm really proud of the way that we've used surveys in Medford to collect really good information from folks. And we've really taken a line from RAP, or Western Regional Advocacy Project, and the folks there who've been doing surveys for quite a long time. But surveys are such a great way to actually get data and the voices from folks who are unhoused and unsheltered, and actually, bring those forward in a way that is a little bit easier to kind of tell the story and counter the narratives that the police or the city or whoever's holding that power might be sharing. We recently did a survey in Medford to point out a lot of the issues with services in our shelters, and to really counter this argument that people are just service resistant. We did I don't know if you can see me, but we recently released our survey results from that. And it was a really great way to identify that like 50% of the people we talked to experienced what they felt was discrimination based on race or disability or sexual orientation. We were really able to get at good information. So I would definitely recommend surveys, definitely recommend building, connections with folks who are creating spaces where people are at, so that you can maintain those ongoing relationships.
Thank you very much, Maig. All right, so, you heard from Maig, it's important to work with organizers. Organizers are able to get a lot of great information. Surveys are a wonderful tool that can be used by organizers. But how do we even get to a point where organizers and attorneys can work together? We're often in different lanes, working in ways that are siloed. There is a lot of legitimate distrust of the legal profession. As we've talked about, the law has been weaponized against people, and lawyers are not trusted. There's a lot of trust building that needs to be done. So how can we do that? How can we build coalition? And for that, I'm going to transition it over to India Pungarcher. India, are you here? Oh, India is not here. So Jeff, can you be our India? Let's see.
I can, yes.
I know that. Let me actually just check, because India, I believe, was going to, she asked about joining. She may not have the Zoom link. All right, everybody, please bear with me for one last technical disruption. I just want to make sure that India is connected. Okay. As is characteristic of good organizers who are in the field, I did get an email from India. She's got an emergency and she's in the field. So she's not coming to explain how she has been able to build a statewide coalition in Tennessee. So a couple of things for everybody to know. Tennessee is one of the locations where there is a Cicero Institute inspired policy. Who here is working in Tennessee? All right, we know Jennifer is, we know Micah is. There is a coalition of attorneys and organizers, and India really has been instrumental in bringing people together that have worked together since the 2 years prior to enactment of the new statewide camping ban that imposes felony punishment on unhoused people. And Jeff, if you could you say a few words about what the new law does and what the punishments are?
Yeah, so essentially across the board, well, most states, when it comes to issues of folks being unhoused and being criminalized, it's generally misdemeanor or civil prosecution. Here in the state of Tennessee, unfortunately, what the General Assembly has done in 2 separate bills across 2 separate sessions of the General Assembly is prescribed and made it a felony offense for folks to be camping. Essentially, the way that it operates, at least how the law prescribes it to be operated, is that the police, whenever they suspect a person of camping on public grounds where camping has not been allowed for and they don't have a permit for camping, the police will then approach them, say, hey, you're trespassing on public property, you've got 24 hours to vacate. If the police then come back and they are still there within 24 hours, then they can be arrested and charged with a felony camping offense. part of the mechanisms of that statute as well is that the first time that the police show up, they can start confiscating things from folks and taking them into custody, essentially a Fourth Amendment seizure. And an unhoused person would have 30 days to then go to the police precinct where all that stuff is being housed, for them to be able to retrieve that stuff from the police. So it's a very draconian statute that's been enacted. We haven't necessarily seen anybody fully charged with the felony as of yet, but there have definitely been threats across all of the major metropolitan areas. Fortunately, here in Nashville, Tennessee, the MNPD and the DA's office has said they will not be prosecuting this offense, but it's still something that as Tristia said, that India's been on the ground doing a lot of work on, and building that statewide coalition, because it is something that we're seeing a lot of.
That's right. Thank you, Jeff.
Mhm.
So, a few things to note. This is the only statewide ban that we're aware of that imposes a felony punishment. The way that we're hearing it's enforced in Knoxville, and we know this through the organizing that's been done and connections that have been made by India and others, is that police will come to an encampment, say we're investigating a potential felonious camping or whatever it is that they say is the pretext for doing searches of people. So they will stop, temporarily seize, do searches of the people, their property, under this guise that they're investigating this felony. If they do start enforcing this particular law and people are convicted, that comes with another major consequence that affects ability to exercise sources of power. And what is that, Jeff?
So essentially, once a person in the state of Tennessee has any felony conviction, they are then disenfranchised from their voting rights. So even if, in Tennessee, you have A felonies to E felonies. An E felony can carry 1 to 6 years, depending on your range, even if you are sentenced to 2 years probation. Since you have that felony conviction on your record, you were then disenfranchised from your voting rights.
Thank you. It looks like, and I think, yeah, we've got time for a question. It looks like David Peary has a question, and I'm going to walk over with him.
Two-part purpose of clarification. So they're using this new statute as a pretext, if you will, in order to give them the policy to come in and search the encampment and see the violations that may be there. Is that exactly?
That's essentially
Okay. And what are the racial disparities involved in this? So what's Miami's? What's Tennessee's homeless population like in terms of its racial disparity? What's the racial impact of this law?
remember to clear David's question.
I had a little bit of difficulty hearing it, but so I guess from what I heard, are you asking specifically about like what the demographics of people in Tennessee that are unhoused and what was the motivation of the state legislature in passing this?
Is that a good summary?
Yeah, what's a disparate impact on people of this law? I mean, what's the percentage of folks who are Black, who are homeless, as compared to the general population?
So he's curious about the disparate impact on communities of color, and in particular, the Black population of people. And if you have any data that you can cite about the demographics of unhoused people in Tennessee who are subject to enforcement.
Yeah, so I don't currently have access to any empirical data to show you, but just a part of my background, I spent the past 3 years at the Nashville Public Defender's Office. And so just anecdotally, definitely saw a large influx in the majority of individuals who we saw sort of targeted for criminal trespass and other things relating to being unhoused here in Nashville definitely does have a disparate impact. I want to say, so Nashville's jail population, I want to say, is just shy of 4,000 folks, and the jail population is upwards of 40% African-American. And a majority of folks here in Nashville who are charged with misdemeanor offenses, oftentimes relating to being unhoused. So there is a disparate impact. I like I said, I just don't have that empirical data readily available to me at this moment, but sort of anecdotally, there is a disparate impact, and especially considering also things out of Shelby County, out of Memphis, their prosecutorial mindset there is it shifted with the new DA that's been elected there. But Memphis is definitely a hotbed for this kind of activity as well.
Thank you very much. All right, so we talked a little bit about strategery. The last thing I will say is, as one thing that I found interesting is, India was one of the first people that we spoke with in Tennessee, and she described as I said, 2 years long before enactment of the Tennessee camping ban that we're discussing, coalition building and an effort that now has over 300 individuals and organizations that are part of the coalition. When we reached out, it was originally around this notion of, potentially taking legal action. What did she and others want to do? And what she said is what's a lot more important than trying to, quickly try to enjoin the newly enacted law. She wanted to build that coalition and spend time focusing just on expanding the coalition that she built to really reach out to people in counties that she hadn't reached. She relied a lot on connections with faith-based organizations, but not exclusively. And the notion is when you have that coalition, when you keep that coalition tight, you are able to respond not just to this particular camping ban, but to criminalization policies and actions more broadly. And so that is really where the action has been focused. And I think that's also an important thing to know as far as strategy is concerned. All right, so we are going to the last segment of our session here. Who here's seen Elf? All right, enough folks have seen Elf. So Elf at one point realizes that Santa in the store is not the real Santa, and he sits on a throne of lies. So I want us to get really comfortable with shouting out the lies. As we heard from Mark Dones yesterday, we hear from proponents of criminalization policies a lot of lies. We hear a lot of lies in the media, and we need to get comfortable shouting them out. So this is the part where I really am going to ask you to please shout out and to yell at me. I'm going to make some statements. And if you hear a statement that is a lie, I want you to yell lies at me. All right, let's get really comfortable. And please feel free in the chat. You can send me nasty emojis. You can do whatever you want to show that you're hearing untruths and I need to be checked. All right, so 1, people live outside because they are lazy and don't want to work. That's right. That's right. So data from the National Coalition for the Homeless shows that about 40% of the unhoused population is working. We know that there are a lot of working families living in vehicles, and people who are disabled are disproportionately represented in the unhoused population. Seniors who have worked their entire lives who are no longer able to afford housing are in the unhoused population. Children who are not legally allowed to work and who are working in our US schools, which now has well over 1 million children, went up to 1.5 million children that were counted. I mean, that's an undercount in and of itself, but counted as homeless, enrolled in US schools, are all part of the population of people that are categorically called lazy, unwilling to work. And we know that that's a lie. So thank you for calling that out. Here's another statement. You can tell me if it's a lie. People live outside because they are service resistant. Lies. Lies. People don't resist services that they can use. People don't resist services that offer dignity, that offer safety, offer stability. And I want to kick it over to Maig because Maig wrote an excellent article about this notion of straw man services. Because we often hear criminalization policies justified on the notion that people have access to services. You'll hear it, you'll read about it in, you'll hear it from city officials when they are justifying enactment or enforcement of their policies. They'll tell the media, we went into an encampment, we offered them services, they didn't want them. And so we have to do what we have to do. And this is just the stick. We're offering the carrot. They don't want carrots. But we know that that's a lie. So Maig, can you tell us a little bit about this notion of straw man services?
Yeah, absolutely. Yeah, I've definitely seen it to an extreme degree where I'm at in Medford. In Medford, pretty much all of the social service providers are accompanied by police when they do outreach. And the entry point to our sanctioned encampment is the only way to get in is through a police referral. And so that in and of itself creates just a massive barrier to people being able to access services. I mentioned earlier the survey that we recently did about the shelter provider in our community. And the biggest takeaway from that was about a quarter of the people we talked to had outlined disability-related discrimination that they experienced at the local shelter. People being kicked out for disability and other characteristics that would fall under protected classes from civil rights law. And it's just a massive issue. I think one of the biggest issues is that we just aren't hearing from folks what is happening, right? And so we're getting the narrative from cities, we're getting the narrative from service providers, and service providers aren't always motivated to share what the barriers are or to be the ones to identify those barriers at their own agencies. So I think it's another good reason to really partner with organizers and folks that are unhoused to be able to share, what those experiences are like. And I think whenever possible, quantifying that is great. I know the Oregonian commissioned a survey a while back for folks in Portland. They talked to 300 different people in Portland, and they found that I think it was like 75% of people that had talked to an outreach worker never heard a call back after they expressed interest in services, right? And so, so there's all these different pieces, but we definitely see that jurisdictions and police are somewhat aware at times of this need to offer services or shelter, and it's really important to kind of find ways to point out the holes in those offers of services, and services just aren't housing. And so that's one of the biggest issues that we see.
Thank you very much, ma'am. All right. So moving right along with my next statement, shelters and sanctioned encampments end homelessness. Thank you. Thank you. And who from the audience wants to take a crack at why shelters and sanctioned encampments do not end homelessness? And I heard it's not housing. It's not housing. There is an internationally recognized human right to housing. It has 7 elements: congregate shelters, temporary shelters of any type. Sanctioned encampments fall far short of the 7 elements and cannot be recognized as adequate housing under a human rights lens and a human rights standard. One of the things that we're preparing now with the support of Alston and Bird is a series of case studies based on publicly available information. So very, limited information. We're not talking with people who are inside of these programs, but we're doing based on the public information as measured against the 7 elements of the human right to housing. How do these programs fare under that analysis? And we really encourage people to think about the temporary settings using that lens. Temporary settings can offer some temporary safety. There are people who are asking for an encampment where they can receive some basic services. There are people who use shelters. Shelters turn people away every day because shelters do offer some critical safety for people who lack shelter, but they do not end homelessness. They should never be seen as solutions to homelessness. And unfortunately, what we're seeing is that they're often drivers of criminalization of homelessness. The existence of those locations are used to justify people's presence outside of those locations. That's right. And Lydia just said that housing security is what ends homelessness. These other temporary interventions are reactionary. Thank you. And David, and can I actually ask folks, as we start to get into the Q&A, every time I take the mic away, people virtually say that they can't really hear. So if you have, yeah, that'd be great. If folks could come up, I'll just set the mic here.
So I just want to say I just want to emphasize the point that Tristia was making, how shelters often enable the criminalization of homelessness, mostly through this term of shelter resistance. And in fact, that's my second worst, the term I hate second most. The term I hate the most is this myth that people choose to be homeless. But the shelter resistance term is a pure myth. And as I said, used to justify criminalization. The example that I use is that you never hear retailers complaining about customers being grocery resistant. Okay, that sounds crazy, doesn't it? You don't blame your customers for not coming into your business. You look internally and you change your business to more appropriately engage your customers. And that's what shelters need to do. Instead of blaming the victims of poverty, they need to look internally and see why their customers are voting with their feet and not coming in. So instead of trying to force their customers to come in, or worse, using it as a justification to arrest them and criminalize homelessness, they need to change the nature of their services to more appropriately engage people who are experiencing homelessness. So reject, whenever you hear shelter resistant or service resistance, you need to reject that out of hand because it's BS. Totally.
Thank you. And Meg, I see you have your hand raised.
Yeah, I absolutely, 100%. And I just want to add that what we saw in our community is that as soon as there was a large sanction encampment created, our city passed a law to further criminalize homelessness, and they used the existence of that sanction encampment to do it. Regardless of the fact that in the survey we just did, 82% of the people said that they don't trust the staff at that shelter or that sanction encampment to listen to them or to take feedback on how to improve. 75% of people that we talked to said that they weren't treated fairly or with dignity. I mean, that's so significant. And so if folks don't want to go somewhere where they're not treated with dignity, they're now further criminalized. So thanks for really spelling that out.
Thank you. All right, well, we have some time for questions. We have a bunch of great panelists, and there is one question in the chat, and this is for Jeff, and then I'll open it up for the audience. But Jeff, can you talk about the circuit split in relation to the favorable disposition doctrine, and what do you think we should know as we're crafting legal strategies to challenge criminalization policies?
Yeah, so as I stated before, with the favorable disposition doctrine, essentially it states that you've got to have exhausted all of your state court and habeas remedies before you can petition the court to invalidate a conviction or hold a statute to be unconstitutional. So the 6th, the 2nd, the 9th, and the 8th Circuit have actually carved out an exception to that doctrine, essentially stating that if you have a misdemeanor conviction and you are sentenced to 11 months and 29 days or on probation for 11 months and 29 days, or any shorter sentence, that term of confinement is going to be so short that you're not going to really be able to exhaust all of your post-conviction remedies and your habeas remedies, just because of that short time frame. So those specific circuits has stated that the favorable disposition doctrine does not apply in those specific instances. So essentially, for most misdemeanor convictions, the favorable disposition doctrine would not apply. So then over the course of that, you would actually be able to get into federal court to collaterally challenge the constitutionality of that conviction and of that statute. And I know that here in Tennessee, essentially the district courts have applied that. But if it's anything over a misdemeanor conviction, 11 months and 29 days, then that exception would not apply, and you would still the heck abstention doctrine would still apply in that situation.
Thank you. And sticking with strategy, there's another question. This is my question for Kirsten, and this is about strategies for determining availability of shelter. And I'm thinking specifically of discovery strategies. Showing that there are not viable alternatives is really key to bringing these 8th Amendment claims under Martin. So can you talk a little bit about considerations for that?
Sure. I think shortly after, very early in my source career, I saw Judge John Walker speak, who was the judge who struck down the Prop 8 same-sex marriage ban in California, and he had said that civil rights lawyers often underestimate the value of a child and having really good factual records, and I kind of really took that with me. And in the vein of making sure that we create our own realities, one of my single most pet peeves in legal opinions is the phrase "common sense dictates something." Fill in the blank. Nothing good ever follows those few words. And so my kind of singular goal is to eliminate any opportunity for a judge to bring their own common sense, and to make sure instead I have supplied that with evidence that has to be accepted. And so in the context of shelter and the availability of shelter space, in the McCardle case, we did that in a number of ways. First, we hired Barbara Poppy, who was former head of the U.S. Agency on Homelessness and was a consultant, to do a study basically of the system and to explain. A line from her expert report that wound up into the opinion was, on any given night, there is at minimum 150 people who do not have shelter in the city of Ohio. And so we also had her explain that people were involuntarily homeless. So she talked about affordable housing and jobs. All of these lies, we had evidence on every single one of them. We also got into knockdown, drag out discovery fights with the Salvation Army, including they did not want to give us their policy manuals because they said it was protected trade secrets. So we won that discovery order, and the court said, neither your policies for excluding people who you banned, your eligibility criteria, how you run your shelter, none of that is secret, and you have to turn over everything and you're allowed to use it in a case. I also think it's really important to supplement experts with local folks. So find kind of your helpers. Find folks in your continuum of care system. We had the head of the lead agency of the continuum of care who testified about their system. We got every single shelter. We did depositions of talking about their criteria. We Salvation Army had trespassed basically half of the homeless population from their shelter, and then lied and said they didn't have evidence of that. And our plaintiff filed a sworn declaration in court that said you keep them at the front desk. There are these notebooks and he described them. And then all of a sudden, ooh, they had them. And so we were able to put together, basically a really comprehensive record that showed not only did our individual clients not have access to shelter on the nights they were arrested, that hundreds of people don't have access to shelter on any given night, that the system can never support all of the people. And we also had city officials that we were, and I've kind of managed to do this in every case I've ever done, where you can always find someone who's not totally on board of like what's going on. And they are a great, credible source of information and kind of corroboration of your other witnesses. So we had good testimony from the city manager, we had good testimony of the head of their homelessness office, all who worked for the city, and kind of had universal agreement. And so the only thing that they had was like the mayor who was running around saying all these like speculative things, like everyone's choosing to be homeless and that kind of thing. And so we were able to exclude that as impermissible lay testimony, lay opinion testimony, because he doesn't get to speculate about the state of mind of like hundreds of people. And so those are some of the ways in which we approach this. And I think that was really important, because in our case you could see some of our first hearings, this court was just kind of like, okay, people just choose, like, what about people who choose to be homeless? That was actually why class cert was denied in our case, because at class cert he was kind of like, oh, I don't know if this is common, because you could have some people who are choosing outside and some people who aren't. And so we knew we had a lot of work to do, and then we ended up getting successful summary judgment in that case.
Great, thank you. Yeah, and Sarah has a follow-up question.
Yeah, so I worked for a small nonprofit that did not have unlimited resources, but shout out to the Impact Fund, which is a great resource for everybody. I wrote a grant to the Impact Fund very early in the case, like right after we filed the litigation, got $30,000 for litigation costs, which felt like, hitting the jackpot. And I was like, could we do GIS mapping? I mean, I was caught up with all kinds of ways to spend that money. And so, but we did have the head of the continuum of care lined up really early, so I felt comfortable moving forward with her even before we had kind of secured Barbara Hoppy. But that is a good idea, because then you can just put that stuff in the complaint, that you kind of already had. Oh, and one other tool. I mean, it's not, we all know, like, folks who work in human services, like, know that it's not ideal, but like sometimes just like the hit counts, like the housing inventory counts, and then the point in time counts. I mean, you can just like compare and contrast, right? Like you can clearly see, here are the beds, they're all full, and here are all the folks who are homeless. And so like that's kind of what I did when I did the complaint. We just kind of went through the housing inventory counts, the point in time counts, and then she came in to do not only a more comprehensive analysis, but she has very clear opinions where she's like, people are not choosing to be homeless, people have power are involuntarily sheltered, the plaintiffs are unsheltered, the plaintiffs will never be served by this payment system as designed. It has high barriers, people can't access the shelter, and the only thing that will get them out of homelessness is permanent supportive housing, and they don't have it. And so it was a very clear kind of picture that she painted.
Thank you. All right. We have time for, I think, one or two more questions. Any questions? Yeah, Claire. I'm sorry, Ellen. Yeah. Thanks. This question goes to one of the first myths in this section about, or in this part about laziness, right? I'm wondering whether anyone has has anyone tried to flip that script and say, like, not everyone's gonna have to work, like my client, Ricky, who passed away, like what he wanted was just basic income, right? Like what he wanted was just like a place to sleep, some food, and to like live out his the end of his 50s and 60s and beyond in peace, you know, and like he didn't want people telling him what to do, he didn't want people telling him how to work. And I think, yeah, what he really wanted was just like UBI, more or less, right? And so I don't know, sometimes I talk with my friend, like, how do we, is there a way to change the narrative around this to just kind of validate that without playing into the everyone's lazy narrative? That's my question. And would you mind coming up here, Lydia, so people can hear you? Thank you very much. That's an excellent question, Ellen, and we have an answer coming. Hi, I'm an outreach worker, so I work with a lot of people experiencing homelessness. I've had this conversation before, and usually I talk about generational wealth. I talk about how a lot of people in this country were just kind of set up to make it in the beginning, and other people were not. So there are a lot of people in this country who don't have to work, but they have the resources they need for when they're born. It's just there are a lot of people who like don't have it because of some big reasons. Like I think 40 acres and a mule is a really great example here. And do we all know where that came from? Like personally, after the Civil War, Black people had occupied about 1/10 of the South. They were inspired by the Revolution and segregated, and they said, you know, we should start demanding land for ourselves, demanding resources for ourselves. And the American government said, okay, let's think about it. And we broke it down. 1/10 of the land that was occupied, broken up among those Black households that were previously enslaved people, it averaged out to every household gets 40 acres. So that's what they thought they were getting. And they were like, oh, you know, we're going to trust the government, we're going to look at them, they'll give us this land. And then they turned around and said, no, actually, we're not going to give you the 40 acres. We're going to give the 40 acres to the white people that previously owned slaves to make up for the fact that they lost their slaves. And then the Black people had to turn around and go work for these previous slave owners in slave-like conditions. That started probably the biggest example of generational wealth in this country. So these white people in the South had 40 acres of land, and probably more if they owned before. That has stayed in their families, and they've been able to build lives with people off of it. And then you have Black and brown people who didn't have any of that, and then were subjected to mass incarceration. They were subjected to these laws that we were hearing in the session before this in this room. Laws that were written when Black and brown people were not considered full humans, yet we still use these laws as precedent for the decisions that we're making today. Yeah, I just think these are very important things to consider. Yeah, I think that's great. I mean, that's I think a really brilliant way to flip the script. You know, another thing that I was thinking about is this notion of what is labor. I mean, there's only some labor that we reward with compensation and that we see as legitimate. And we know that women, for example, do a lot of unpaid labor. Caretakers do labor that benefits the community, but that is not recognized as work. So that's another, you know, potential way to flip the script, as you're saying. And I see a couple of hands up. And again, just for folks in the virtual audience, if you can come up here. And we've got, well, we're technically at time, so I think Lily and then Kelly, and then we'll wrap up.
I was just going to say, I think Lydia's answer is absolutely correct and perceived as well. But two things that like definitely the law center and our partners are trying to do in terms of changing the narrative is one, like do kind of like a take a walk in their shoes type of thing, where if you take someone through like so the rhetoric or whatever is tell that person who's unsheltered to just get a minimum wage job, tell them to go apply for the McDonald's, whatever. Okay, why don't you go to try to apply to work at McDonald's without a permanent address? Like, do you think they pay cash? Like, you need to be banked. Like, there's a lot of reasons why people who are unsheltered can't actually access even minimum wage work. Both that you need a permanent address and you need to be banked, and you need to have access to like identification cards and all of those things. So, like, actually taking someone who has that mindset through the process of like, pretend that you are unsheltered. How are you actually going to get a job? And then even once you do get a minimum wage job, can you afford rent. In most major cities. And then the other thing is like SSI and SSCI were created to be livable wages, and we know that they're not. So in order to qualify for SSCI, you need to show that you can't work, but then you can't afford rent if that's your only source of income. And by definition, it's your only source of income. So that is one of our arguments in our legal residency case in San Diego, is like most of the clients have chronic health conditions, have disabilities. So they can't work, they have to prove that they can't work in order to qualify for SSDI, but there's nowhere in the city or county of San Diego where they can afford rent if that's their only source of income. So what are you supposed to do? So like when you do take people, I think, through those steps, then I mean, some people obviously their mind's not going to be changed, but you can kind of be like, what is that person supposed to do? Like, it's not a matter of laziness, it's a matter of like, they can't work. They physically can't work, they logistically can't work, they practically can't work. And I think there's like a lot of work to do around like the norms. Like if they don't want to work, like can we make a society where people can still be housed? But yeah, I think it's a really good question.
Agreed. Thank you. Thank you. Excellent answer, Lily. And I see that Meg also just added in the chat, and I'll read it out for folks. She's thinking of the labor unhoused friends are doing for one another to stay alive and support each other. So that, you know, that's another way that we can think about work and labor and how it relates to this myth lie about laziness. We've got time, I think, for one last question. Are you able to come up here, Kelly? I can come to you if that's preferable. Thank you very much. And this is Kelly Miller, longtime friend of the Law Center.
Hello. Okay, so you all want to flip the script. So I'm going to give you something, and I want you to shut your eyes for just a moment. And I want you to think about the game Zelda. And if you know anything about the game Zelda, you travel through the space and you collect things along the way, such as a hammer and fire and different things to help you to survive. And you go through the levels. Well, homeless people are the most unlazy human beings on earth, because you are playing on level 1 every day. You know in your mind you get to go home and go to sleep in a safe environment. You don't have to wonder or worry. You could have had a bad day at work, but you know that in 8 hours it's done and over, you could reset yourself and you're safe. All your needs are met. Homeless people are 24/7 in a trauma because they have to deal with everything all at once. There's no sick days, no vacation days. There's no, I mean, if you're sick, you're on the street tripping. You can't, there's nowhere to hide. You're in the public. You can't be embarrassed because this is all you can do. And you have to deal with people who say you're lazy when they're the ones that are complaining and they're the ones that have the relief, and you're sitting here with no relief and no respect. And homelessness is not because of mental illness. That is like number 9 or 10 on the list. And when you say that it is, then that's disrespecting every single person that has experienced an issue that causes homelessness, such as a lack of a job. A company shuts down and hundreds of people are unemployed, a flood, a natural disaster, a death, a divorce. So many things can cause homelessness, and you've got to get out of that stereotypical generalized ignorance that homeless people are mentally and substance challenged only, and that they are lazy and don't want to work and want to be there. That is your excuse for ignoring that people need assistance and that people are struggling every day. Every day. I bath on the street. I sleep on the street. Everything I do on the street. I'm here. I'm being a voice. Did you have it that easy last night and this morning? I froze to death last night. You got to stop saying these things because You represent us. So don't feed into the narrative that is uneducated, uninformed, and unrealistic. We are not lazy. It takes a lot out of a person to function daily, to get your needs met. You got to go to this end to get this and this end to get that. It's structured and set up to cause you to fail. And she put it perfectly. Okay, I get a job. I have to take this with me. I don't have anywhere to leave it. Are you going to provide me space to keep that? Are you going to set me up a bank account? Are you going to feed me? Because the places that feed me are only open during the day when I'm out here working. How am I going to get a shower? You don't think things through sometimes, and you really need to put yourself in their shoes and see all the things that keeps them and prevents them from being successful. And think about that. I'm on level 10. I'm killing it. And I've got none of those things. I don't have fire. I don't have none of those things. So flip it yourselves and go out there and tell people it's flipped. Look at it differently. Thank you.
Thank you, Carly. All right, I can't think of a better note to close this session out on. So thank you all very much for joining us today. I do want to give the last CLE code. It's survival. The first one was strategy. Second is survival. I think now it's time for lunch. Thank you all for joining us. Thanks to a great panel. Thanks for the great comments.